Are you looking for a billing company that can increase your revenue, effectively manage your credentialing, deliver the right software, and provide guidance in navigating the minefield of compliance? MediStar has been providing the right answers for hospitals and physicians for over 13 years. We go the extra mile by paying attention to the details and focusing on aggressive follow-up. Recognized for 4 straight years by Inc. magazine, our professionals can help you attain your revenue cycle goals while helping to ensure that your work is done in a compliant manner. Call one of our experts toll-free at 888-423-8080. That's 888-423-8080. Or visit us at www.medistarbilling.com.
And we're back here again on the Healthcare Business Network. Again, you can find us at hbnradioshow.com. That's hbnradioshow.com. And by the way, for all of you who likes the social media of the day, we're also on Facebook. We have the Healthcare Business Network Radio Show fan page. We're also on Twitter. Username HealthBizNet. That's Health, B-I-Z-N-E-T. We're also on LinkedIn under the Healthcare Business Network Radio Show group, and on YouTube, the Healthcare Business Network channel. So here we are. We're continuing our discussion of Obamacare here with Bill Finerfrock. And Bill, next question we wanted to get to here, where do we stand right now regarding the state court challenges to Obamacare, regarding Obamacare's constitutionality?
Sure. Just a slight correction. They are federal court challenges that were brought by the state.
Excuse me, I stand corrected.
That's all right, but I just don't want your audience to be confused here. We have essentially right now where we stand is that there were a number of lawsuits that were brought by various individuals, states, organizations, almost immediately after the president signed the Patient Protection Affordable Care Act legislation into law. Two federal courts have ruled that the statute is constitutional and that they didn't perceive any problems with the legislation. However, two courts, Virginia, representing the Eastern District in a lawsuit that was brought by the state, or the Commonwealth, I should say, of Virginia, challenging the individual mandate provisions of the legislation requiring individuals to purchase health insurance. Judge Henry Hudson, speaking on behalf of the federal court, ruled that the individual mandate was unconstitutional. That was in December. Then a few weeks ago, Judge Vinson down in Florida also ruled that the individual mandate was unconstitutional. And that lawsuit was brought by the state of Florida as the primary litigant, and they were joined by 26 other states joined with Florida in that, along with the National Federation of Independent Business and two individuals. Were all party to that suit. And as with the case in Virginia, Judge Vinson ruled that the individual mandate was unconstitutional. However, Judge Vinson went further than Judge Hudson did in that Judge Hudson's decision and ruling was narrowly to the individual mandate provision. He did not speak to any of the other provisions of the statute. Judge Vinson, however, ruled that because the legislation was so intertwined, all of the various provisions, particularly the insurance market reforms, things like pre-existing condition, caps on lifetime limits, things of that nature, were so intertwined with one another that he declared the entire law unconstitutional. And that was possible because of the failure of the Congress in passing the Patient Protection Act to include what's called a severability clause. Typically, when legislation is passed that may be considered constitutionally challenged, the Congress will insert what's called a severability clause, which essentially says if any one provision of the bill is declared unconstitutional, that ruling only applies to that particular provision, and all other provisions of the law would be deemed constitutional unless specifically challenged and specifically ruled unconstitutional. Congress didn't include a severability clause in the PPACA, and therefore it left it up to the discretion of the judge to make that decision. And so Judge Vinson, having that discretion, ruled the entire law unconstitutional. Now, the next step in the process would be that legislation would go to, or the lawsuit would then go to the appellate court, the appropriate appellate court, for ruling, and all sides have already acknowledged that this will end up at the Supreme Court at the end of the day, regardless of which side were to have won at the federal court level, which side wins at the appellate court level. It will all end up at the Supreme Court.
Which leads me into my next question about this whole process of fast tracking, meaning you have discussion now from some of the state attorney generals saying, look, let's not waste time.
Right.
Let's go right to the Supreme Court and get this decided. But on the other hand, you have the Obama administration saying, whoa, slow down. Let's go through the whole process. Let's go to the Court of Appeals, Federal Court of Appeals, and then we'll go to the Supreme Court. What do you think? Is this just political posturing here that, Obama and the Department of Justice are against fast tracking this case?
Well, they've certainly said that they want to go through the appellate court, and in their pleadings, they did. Virginia has formally requested that the Supreme Court accept this under the rules of the court, which would allow them to reach down to the district court and bring it immediately to the Supreme Court. The Justice Department has thus far objected to that and has indicated that it wants the appellate court to hear. Now, constitutional legal scholars would say, well, there may be some insight, a perspective that the appellate court might make that would be instructive to the Supreme Court, and therefore that's why the Justice Department wants the opportunity to have the appellate court hear it, to have greater consideration and fleshing out of whatever issues there may be. Those who are in favor of the fast track and who believe that actually what is motivating the Justice Department is to try and slow this process down, that through the normal appellate court, Supreme Court process, it will take probably another 1.5 to 2 years to get the case to the Supreme Court and get a decision. That would put us into 2013, and the majority of the provisions would have to go into effect in 2014. Leaving it in limbo requires a lot of administrative action on the part of the federal government, on the part of the state governments, which they presumably would continue to engage in, so that by the time the Supreme Court were to rule, many of the pieces would be already put in place by the states and by the federal government to operationalize the Affordable Care Act. And there's a school of thought that says that part of the reason for the administration wanting this to go through is that would have some influence on the court to, with regard to their decision on the constitutionality, saying, well, look, the states have spent all this money, the federal government has spent all this money to comply with a provision that's going to kick in here in just a few more months. It would be so costly, so expensive. We maybe, even though we might think that it's questionable on constitutional grounds, we're going to come down on the side of it being constitutional simply because so much money has been spent to get us to this point. So, why are they doing it? I think there are arguments on both sides. Everybody's going to have to look at it and draw their own conclusion.